Yo, what's up, man? June 25th, Wednesday, 2025. Um, Thank y'all for coming. Thank you for subscribing. Please share this video with somebody else that you know that's watching the Puffy trial. I've been covering the Puffy trial every day since the case started. Even before that, you can go on my channel. I've done about 60-something videos on this trial. Shout out to all the new subscribers. You can follow me on Instagram at The Podcast with Soul, and also follow me on Spotify at The Podcast with Soul. Overnight, actually this was dated June 24th, 2025, 3 charges have been dropped in the Puff Daddy RICO case in federal court. June 24th, 2025. This is an 8-page letter from the prosecution. Judge Submaranian, the government respectfully writes regarding its requested edits to the court's proposed jury instructions. The government understands the court's desire for streamlined instructions. With that in mind, the government has suggested ways to streamline those instructions. Specifically, the government has removed instructions from the charge relating to attempted kidnapping under both California and New York law, attempted arson under California law, aiding and abetting sex trafficking. The government is no longer planning to proceed on these theories of liability, so instructions are no longer necessary. The government has also attempted to simplify the language relating to count 1, a proposal, as explained in the government's comment bubbles, that the government hopes not only serves the purposes of streamlining the instructions, but will also avoid any confusion as to the operative agreement for count 1. So, this is a huge, huge win for Puffy. I have always said that the prosecution was given a weak case from the beginning, and that the prosecution and the prosecution's witnesses that they call to testify on the stand would get on the stand and get annihilated, would get destroyed under cross-examination, would get eviscerated under cross-examination. Reasonable doubt is everywhere, all over this case. However, if you watch other YouTubers and mainstream media, they only focus on the direct examination, where the government comes out and it states their charges and the evidence, no matter how flimsy that evidence may be, no matter how many misrepresentations, lies, or flat out perjury is in that information, the government presents that information under direct examination, where it has usually met with its witnesses. It met with Mia 31 times, Dawn Richard 13 times, Capricorn Clark 13 times, Jane Doe 24 times. So they meet with these witnesses to prep them as to what to say when they get on the stand and how to handle cross-examination. But when the cross-examination comes from Puffy's legal teams, their whole testimony gets dropped, gets taken down, gets destroyed, gets demolished, holes poked in everything, reasonable doubt all over the place in every single witness. The government had not presented one witness that, other than like the Homeland Security agents, and even some of them got destroyed. The government has not presented, the federal prosecutors has not presented one witness that when they got off the stand, you said, they got Puffy on that one. Not one. Every last witness that got on the stand, got cross-examined, when you got off, you said, man, nothing of what she said means anything. Nothing of what he said means anything. Every last one of them. So they go on to talk about the SEX trafficking and forced labor. And, basically in this document, the prosecution is telling the judge that although we are going to relax on the arson, the kidnapping, and the aiding and abetting and the SEX trafficking, we want to still give you instructions on some of the other charges. But to me, this is a sign of weakness. This is a sign of weakness. You get all the way to the day before closing arguments and you start peeling back and dropping charges against a man that you had on trial for 6 weeks with evidence that you knew was weak. While the government has taken seriously the court's desire for brevity, the government still strongly believes that certain limited additional instructions on SEX trafficking and forced labor instructions, which are regularly given in SEX trafficking and forced labor trials in this circuit, are necessary for the jury to adequately understand the law on these charges. Each of these instructions reflect established case law and are directly relevant to key issues in this case. Moreover, without such instructions, the government has serious concerns that the jury may misunderstand the applicable law for both charges, which are extremely complex legal concepts about which jurors may have preconceived or mistaken notions. The government has listed the precedent for each of these instructions in its comments to the forced labor and sex trafficking sections of the request to charge. To avoid repeating that law and precedent here, the government limits the below largely to providing the government's reasons why, based on the particular facts and issues in this trial, these additional instructions are necessary. So in the SEX trafficking and forced labor, earlier consent is not determinative. Due to the particular facts of this case, the government believes that it is imperative that the court inform the jury that prior consensual activity is not determinative of whether a victim was SEX trafficked. As this court is well aware, the facts of this case involve instances of trafficking of Jane and Miss Ventura that follow instances of consensual SEX activity, a topic that is likely to be discussed extensively to both parties during the closing arguments. So what they're saying is, throughout this case, throughout the direct examination and throughout the cross-examination, both Cassie and Jane Doe have repeated over and over, verbally on the stand and in text messages and voice notes, that they were down for consensual SEX, that they were with it. They were with the freak-offs. They were with the hotel nights. They wanted to do it. They loved doing it. And what he's saying, what the government is saying, that because that may be true, it doesn't mean that at other points that they weren't trafficked or forced labor or coerced. But this is their case. The same is true for forced labor. The government's forced labor theory focuses on 4 victims, Cassie and Jane, with regard to their participation in freak-offs or hotel nights, and Mia and Capricorn Clark with regard to their employment for the defendant. Similarly to SEX trafficking, Cassie and Jane's prior consensual activities do not preclude a finding that later non-consensual SEX acts are forced labor. Then they cite a case. A victim's initial willingness to perform certain labor does not preclude the possibility that the victim's continued labor may become forced. Nor does the fact that Mia and Capricorn Clark willingly took jobs with the defendant preclude a finding that both at some point were forced to work. Yesterday, during Alexandra Shapiro's motion for Rule 29, she stated that Mia and Capricorn Clark were free to leave and go and work wherever else they wanted to. I think Capricorn Clark went and worked with Madonna at some point, or was that Mia? Like they both left. Capricorn Clark went to work with 50 Cent. Mia went to work with Madonna. They were free to leave. There was no forced labor, and both of them expressly stated after they left the employ of Puffy that they wanted to come back and work with him more. They did not like what job they were doing, and they wanted to come back and work for him. So this is then they talk about the payments, the fact that Puff is paying Jane Doe's rent of $10,000 a month, that shouldn't bear on the fact that because he's helping her financially, that she is not being trafficked. For sex trafficking, this instruction is crucial because of the fact pattern underlying Jane's trafficking by the defendant. As Jane testified, the defendant and Jane entered into a multi-year love contract under which the defendant agreed to pay Jane's rent in the amount of $10,000 each month. While that contract was in effect, and in part as a result of the terms of that contract, the government alleges that Jane was trafficked because jurors may be under the mistaken impression that someone cannot be coerced if they received compensation in return. The government requests that the jury be instructed as to the law that payment alone does not preclude a finding of guilt as to sex trafficking. Because the forced labor victims also receive money or gifts from the defendant, it is important to instruct the jury that payment does not preclude a finding of forced labor in order to prevent confusion. The defendant paid Jane's $10,000 per month rent and similarly paid for Cassie's rent and other expenses. In addition, as employees, Mia and Capricorn Clark were paid salaries by the defendant's company. The juror may not intuitively understand that this payment does not preclude a guilty finding of forced labor. How could Mia, what they're saying is Mia and Capricorn Clark can still be subjected to forced labor even though they're receiving a salary, they have a job description, and the fact that they're receiving a salary, that doesn't negate that there's forced labor. Like they could be receiving their salary, working, and there's still forced labor. This is the government. Physical restraint. Based on the cross-examination of Jane and Mia, the government respectfully requests that the court briefly instruct the jury that physical restraint is not required to establish sex trafficking and forced labor. As this court is aware, one of the key instances of trafficking of Jane that the government intends to discuss at length in its closing, and which the government anticipates that the defense will also address in closing, involves the defendant's assault and subsequent freak-off involving Jane in June 2024. During cross-examination about this incident, defense counsel extensively questioned Jane about times that she could have escaped on this date, asking Jane, does the back gate have the capability for you to leave the house? Asking whether she has other family members in Los Angeles. Moreover, during today's Rule 29 motion, defense counsel again argued that Jane could not have been trafficked on this date because she could have left. Because of the defense's lengthy cross-examination on this point and expected arguments at closing, and to avoid confusion, the government requests that a brief instruction be added on this point, making it clear the legal import of this evidence. Similarly, during the cross of Mia and in the Rule 29 argument today, the defense repeatedly argued that Mia could have left her job at any time and is therefore not a forced labor victim. This is incorrect under law, and the instructions needed to correct any misimpression in the jurors' minds that Mia had an affirmative duty to leave. And they go on and talk about The other charges, let's read one more. SCX trafficking. Defendant need not receive thing of value. The government respectfully requests that the court add a single sentence to its charge on SCX trafficking to clarify that the defendant need not be the person who receives the thing of value from the SCX Act. The government believes that this short instruction is necessary here due to the particular relationship between the parties and the potential that jurors will be influenced by preconceived misconceptions about trafficking that do not comport with the law as it is explained to them. Unanimity. Check this part out. Unanimity. The government objects to the unanimity instructions for the SCX trafficking and Mann Act offenses. The government has been unable to find a single first SCX trafficking and Mann Act case where a unanimity instruction was given, and are concerned that the language as drafted will introduce error into the charge. Accordingly, the government proposes the following language, which is designed to reduce the risk of error and confusion. The intent of these edits, among other things, is to properly characterize what constitutes the relevant instance and to make clear that unanimity is only needed for certain elements, not means. Counts 2 and counts 4, proposed instruction. The government has argued that the defendant committed SCX trafficking with respect to Cassie for count 2 or Jane for count 4 over a years-long period. To find the defendant guilty of these counts, you must be unanimous that the government proved beyond a reasonable doubt all the elements of the charge with respect to at least one specific instance of SCX trafficking within that period. As to that specific instance of SCX trafficking, you must agree that all the elements were met beyond a reasonable doubt. But you need not agree as to the way in which the elements are satisfied or all the details of the instance. Counts 3 and 5, proposed instructions. The government has argued that the defendant violated federal laws regarding to transportation to engage in prostitution with respect to Cassie, among others, for count 3, and with respect to Jane, among others, for count 5, over a years-long period. To find the defendant guilty on these counts, you must be unanimous that the government proved beyond a reasonable doubt all the elements of the charge with respect to at least one specific instance of transportation to engage in prostitution within that period. So, the government conceded 3 charges, but they are reaffirming how they feel about the other charges, and we'll see. We go to court later on today at 2 o'clock. They're going to discuss this, and I'll have a report for you then. Peace.